We are going back on the record. Michelle, are you ready? Okay. The first up on the docket is docket number 2022-005 in the matter of notice of agency action by the division seeking an order forfeiting the reclamation bond provided by Gold Star Stone, Inc. This matter was dismissed pursuant to board order filed on 4/20/22. So we will move on to item number 2. Item number 2 is docket number 2022-007 in the matter of request for agency action of Urban Oil and Gas for an order 1, modifying the board orders entered in causes 241-01, 241-04, and item 2, providing an exception location for the proposed Lutod 33-22 well. At this point, do we need to swear in witnesses, Mr. McDonald?
Appearances of counsel first, Madam Chairman.
Appearances of counsel.
Fred McDonald of Lear & Lear of counsel, and on behalf of the petitioner, Urban Oil and Gas.
Thank you. Do we have any swearing in of witnesses?
Just real quick, Trevor Gruel on behalf of the Division of Oil, Gas, and Mining, and I'm an Assistant Attorney General.
Thank you. Now we're moving on to witnesses.
Now we're moving on to witnesses.
Thank you.
Yes, Madam Chairman. With me today on behalf of Urban are Mr. Art Vermillion, who's the senior landman who will be appearing virtually. Art, do you hear us okay?
I can.
Good, okay. Mr. Michael Schneider, who's the exploitation manager, and Mr. Michael Wade, who's the chief of operations of the Rocky region, and I ask that they be sworn in at this time.
Will you each raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Members of the board, the resumes of all 3 witnesses were collectively submitted as Exhibit A in this cause. If separately and individually asked about the contents of their resumes, each would confirm the same. Mr. Vermillion will be a fact witness only. Mr. Wade was previously recognized as an expert in petroleum engineering in cause number 072-01 last year, and presuming the division has no objection, we request that the board again recognize him as an expert in petroleum engineering for purposes of this cause.
The division does not object to this.
Thank you. So accept.
Okay, thank you. And since this is the first time Mr. Schneider has appeared before the board, we will be qualifying him as an expert in geology at the commencement of his testimony. I'd like to confirm that the board received corrected exhibits J7 through J12, substitute exhibits L1 through L4, and the supplement to exhibit Z, which was filed this past Monday.
Yes, we
Thank you.
received them.
Also, Madam Chairman, I'd like to confirm that it's acceptable to move for admission of my exhibits at the end of my presentation in chief.
Yes, that's fine.
Thank you. Members of the board, Urban is before you today seeking infill authorization to drill the proposed Helper State 2211, the Wellington Federal 22-14, and the Wellington 42-14 coal bed methane wells as the second well within each previously established 160-acre Farron Formation drilling units. We're also asking for approval of an exception location to drill the proposed Leotard 33-22 well as the initial well within the previously established 160-acre drilling unit, but closer than the eastern boundary setback. Specifically, under the board's orders entered in cause numbers 241-01, 241-04, and 241-09, one well upon each of the relevant quarter sections at issue is allowed for the production of gas, including coal bed methane, from the Farron Formation. The well cannot be located closer than 460 feet to a drilling unit boundary and closer than 920 feet to a well producing from the same formation without an exception location pursuant to Utah Administrative Code Rule R649-3-3. True and correct copies of the 24101, 24104, and 24109 orders were collectively submitted as Exhibit B in this cause. It's been several years since the board has heard a coal bed methane issue. And in fact, I don't recognize any of the board members the last time I was appearing in front of it have heard a coal bed methane issue. The key here is it requires contrarian thinking with coal bed methane. Specifically, coal bed methane development is the antithesis of pressure maintenance. In other words, you want communication and interference to allow the gas to escape from the coal matrix. That's contrary to what you would want with a typical oil and gas well, that you don't want to have the communication between the wells. And Mr. Wade will go into that a little bit further. In 2010, Anadarko Petroleum Corporation, Urban's predecessor in title and operations in this area, speculated that one well per quarter section drilling unit would not be recovering all of the gas resource. It therefore sought and received board approval of an infill pilot project in cause number 24101A. A true and correct copy of that order was also submitted as part of Exhibit B. As the testimony will reflect, Anadarko's pilot program, coupled with the performance of the current wells located in the subject drilling units to date, strongly suggests that one well alone is not recovering all of the gas resource, and therefore infill drilling is required. The testimony will also address why Urban selected these particular well locations for these wells. As to the exception location approval, Urban sought the requisite written consent to drill the well closer than the allowed 460-foot setback, but has been unable to obtain the consent from all of the owners in the adjacent drilling unit. Thus, as required under R 649-3-3, it seeks approval directly from the board. As the testimony will reflect, correlative rights are protected by virtue of primarily common production interest ownership and the fact that notice of the proposed well locations and of this request has been properly provided, received, and there have been no objections. The board has jurisdiction over this cause pursuant to Utah Code annotated sections 40-6-5 subparagraph 3B and 40-6-6 subparagraph 6 and 7, and also Utah Administrative Code Rule R 649-3-3. Copies of the request were mailed via certified mail to all owners within the subject drilling units and the adjacent drilling units on lands in which the proposed wells are closer than the current allowed setbacks. These were sent to their last addresses as disclosed by the relevant BLM, SITLA, and Carbon County records and Urban's internal land records. Exhibit Z, as supplemented, reflects return receipts, return mailings as unclaimed, or USPN queries as to any mailings for which return receipts or mailings were returned. However, you'll notice that every party who was notified on the certificate of mailing did receive the request. In addition, notice of the filing of the request and this hearing was also duly published in the Deseret News on April 1st, 2022, the Salt Lake Tribune on April 3rd, 2022, and ETV News, which is the local Carbon County media, on April 6th, 2022. No objections or responses to the request were filed, and the division elected not to file a staff memorandum in this matter. With that, I'll commence my examination of Mr. Vermillion. Mr. Vermillion, would you please state your name and business address for the record?
Yes, it's Arthur Vermillion, 1000 East 14th Street, Plano, Texas, 75074.
And what is your current position with Urban?
I'm a senior landman handling and supervising land manners for the Helper and Cardinal Draw fields.
Which are the areas at issue, correct?
Correct.
Would you please provide for the record what the corporate and bonding status of Urban is?
Yes, Urban is a Texas limited liability company with its principal place of business in Plano, Texas. It is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant federal and state of Utah agencies. Urban is duly designated operator of its related entities, Urban Fund 3 Limited Partnership and Urban Oil and Gas Partners C1 Limited Partnership, and both entities fully support Urban's request. Urban also owns fee leases covering portions of the lands at issue.
All right, Mr. Vermillion, on your feed, can you see the PowerPoint presentation?
Yes, sir.
Okay, I'm going to show you what have been marked as Exhibit C through E. Do you recognize those documents?
Yes, I do.
Were they prepared by you or urban personnel with your review and input, or are they also considered official business records of urban?
They were prepared by urban personnel and reviewed by me and are official business records of urban.
Thank you. Turning your attention now to Exhibit C, which is shown on the PowerPoint presentation right now, would you please explain to the board what this shows?
Yes, Exhibit C is our regional locator plat. And what this map will show is sections at issue are sections 11, 14, 22, and 23 of Township 14 South, Range 10 East in Carbon County. This is located just on the eastern outskirts of Price City. It also reflects Urban's proposed wells. If you'll note, the well in the southwest quarter of section 23 is in conformance with the 241-09 order and therefore is not at issue in this cause.
Okay, now turning your attention to what has been marked as Exhibit D, would you please explain to the board what this shows?
Yes, Exhibit D is our plat of area at issue existing wells and proposed wells within their current setback shown. The oil and gas in section 11 are owned by the state of Utah and subject to a SITLA lease under which Urban Fund and Urban Oil and Gas Partners are the only lessees and operating rights owners. Production interest ownership is uniform. There are 4 producing wells in each quarter section of section 11. The maximum currently allowed under the 241-01 order. The proposed Helper State 22-11 well is shown in the northwest in the outside of the current 460-foot setback under the 241-01 order. The oil and gas in the west half and the northeast quarter and the west half of the southeast quarter of section 14 are owned by the United States and subject to a federal lease under which Urban Fund and Urban Oil and Gas Partners are the only lessees and operating rights owners. Production interest ownership is uniform.
I would like to point out at this point to the board and to council that the request mistakenly stated or implied that the lands in section 13, which is the adjacent land, were unleased. Mr. Vermillion will get to that in a minute, but I just wanted to point that out at this point. Please continue, Mr. Vermillion.
Thank you, Fred. The oil and gas in the east half, southeast quarter of section 14 are owned by Carbon County and subject to a lease under which Urban Fund, Urban Oil and Gas Partners, ConocoPhillips Company, and Buzzards Bench LLC are lessees. There are 4 producing wells in each quarter section of section 14, the maximum currently allowed under the 241-04 order. The proposed Wellington Federal 22-14 well is shown in the southeast quarter of the northwest quarter, and the Wellington Federal 42-14 is shown in the southeast quarter of the northeast quarter, both outside of the current 460 setbacks under the 241-04 order. Urban contacted both ConocoPhillips and Buzzard Bench prior to the filings of the RAA and the well locations and to confirm if they had any concerns. Neither party responded with any concerns. Both were sent the RAA as well, and neither filed a response nor made an appearance. Mike Wade will address the technical and practical justifications where these locations were selected when he testifies. The oil and gas in the west half of section 13 are owned by the United States and subject to a federal lease under which Urban Fund and Urban Oil and Gas Partners are the only lessees and operating rights owners. Production interest ownership is uniform. However, as shown, the Carbon County Airport is located on these lands, and as a result, the lands probably will never be drilled. The BLM has also sent the RAA, and no response or objection from it was received. The oil and gas underlying the southeast quarter of section 22 are owned in fee with over 93.125% leased to Urban. The proposed Leota 33-22 well is shown in the northeast quarter of the southeast quarter of section 22. It will be the first well drilled in the drilling unit comprised of the southeast quarter under the 241-09 order, but as shown, it is outside the 460-foot setbacks under the 241-09 order. Urban and Urban Fund and Urban Oil and Gas Partners have approximately 95% of the oil and gas in the southwest quarter of Section 23 under lease or under agreement to lease, and all three consent to the proposed Leota 3322 well location. However, the remaining 5% of the oil and gas is collectively owned by Tyson Stevens, Sean E. and Audrey Steve Anderson as joint tenants, and Glenn A. and Esther M. Clark as trustees of the Clark Family Trust, but is currently unleased. Urban Oil and Gas has attempted to lease and or secure the written consent of these unleased owners for an exception location approval, but to date have not been successful on obtaining those leases and therefore getting their consents. All of these owners were sent the RAA and none responded or have appeared today.
Thank you. Now turning your attention to exhibits E1, E2, E3, E4. I don't think we need to look at them in detail, but just explain to the board what the collective exhibit E's are.
Sure. These are the 4 survey plats for the proposed wells, providing a more detailed reflection of their respective locations.
All right, now, Mr. Vermillion, I'm going to direct your attention to the original and supplemental certificates of mailing. These were pleadings that I filed on behalf of Urban and are on record with the board. Do you have copies of those in front of you?
Yes, I do.
Okay, do you recognize the names of the people that are listed on those certificates?
Yes, I do.
And who are those parties?
The parties on this certificate on the original one is ConocoPhillips Company, State of Utah and Institutional Trust Lands Administration, United States Bureau of Land Management, Utah State Office, the United States Bureau of Land Management, Urban Oil and Gas Partners C1 Limited Partnership, and Urban Fund 3 Limited Partnership. In the supplemental certificate of service, we have Sean and Audrey D. Anderson, Clark Family Trust, to the attention of Glenn and Esther M. Clark, the estate of Callie Marie Huntsman, and Tyson Stevens.
All right, and how were those names and addresses compiled?
They were compiled by searching the records of the BLM, the SITLA, and Carbon County records, and our own internal records here at Urban Oil and Gas.
Okay, at this point, members of the board, I would direct your attention to Exhibit Z as supplemented. These are true and correct copies of the certified mailing receipts received by my office, confirming a receipt of a copy of the request for agency action by all those parties in this matter. With that, that concludes my examination of Mr. Vermillion.
Thank you.
Does the division have any questions of this witness?
Yes. And with Madam Chairman's permission, we'd like to have some of the division staff be able to ask those questions directly. Is that appropriate?
Yes.
Perfect.
So Dustin Doucette for the division. Maybe just on this exhibit here would be a good one to ask this question. Are you not planning on sharing any of the proceeds from the production of these wells with the offsetting drilling unit owners? So for example, on this, you've got your well located on this exhibit on the northwest quarter. Are you sharing with any of those adjacent drilling units?
Well, we had not intended to do that sharing agreement. We felt that following the proper order of giving notice to all those parties to give them an opportunity to object to us would cover that issue effectively. We do have all of that under lease. It's all the same, mineral owners leased. So, and we own all of the, as lessee, all the lessee rights. But we had not contemplated on doing that, for we felt that that was fully protected by giving them proper notice.
Could you please clarify which exhibits you're referring to here?
This one is Exhibit E1, which is Section 11, and I believe Mr. Vermillion testified that this is covered by one sitla lease with common ownership, the entire section.
That's correct.
Yeah, so my question is not specifically on E1, it's on E1 through E4. And so the question's more broad about all of the situations. So I understand maybe on E1, as your testimony, and as Fred pointed out, may not be differing ownership, but I believe your testimony on some of the other wells, there were some differing ownerships within those drilling units. Is that correct?
There is, yes. If you refer to E3, for example, on the Wellington 4214, that one would have some offsetting interest that's owned partially with Urban, with Conoco and Buzzard, and which were properly notified, and we've had I've had talked with them as well, and they did not have any objections or file any motion to object. So, we felt that under the proper process of notice and reaching out to them, that their rights had been protected.
Do you know if they were under the impression that they would be sharing in production from those wells?
They were not under the understanding that they would be.
One other question: is there differing like royalty interest owners on these offsetting drilling units as well?
Yes, we have, if you look at the ones up in section 14 and the helper in 11, of course, most of that is all BLM or sitla leases. So, we know that the mineral ownership is uniform, and we have that fully leased, and Urban is the owner of those. We do have the one lease that is commonly shared in ownership with Buzzard Bench and ConocoPhillips, which we of course have addressed and given them notice as well. Down in the Leota well location, down in sections 22 and 23, Urban is the only lessee of record. We own all of those leases. The majority of the interest in those sections is fully leased, and we are continuing to button up the remaining few mineral interest owners that were unleased, and not able to show them as leased in time for this hearing. But we've given all of those parties, proper notice, so that anybody would have an opportunity to come forward to Urban or to make an objection, through the process itself. So we feel we've covered that very effectively.
So when you say all those parties, are those all the royalty interest parties as well? They were all
Yes,
notified as well?
Yes, sir. That's right.
Okay, thank you.
You're very welcome.
Just to follow up, Mr. Vermillion, earlier in the discussion, it was mentioned that Urban attempted to obtain written permission from all owners within 460 feet. Does that include the Buzzard Bench and ConocoPhillips?
It does. We notified them directly before we even filed our motion, and then they were, of course, duly notified during the filing process of the motion itself. So.
And was there notification for owners in the offsetting drilling units?
Yes. Yes.
And just to clarify, and I might be splitting hairs here, I apologize if I am. Was there an attempt to get the ConocoPhillips and Buzzard Bench to sign off on an exception location? Or was it just notification of your intent to come before the board?
It was notification. I didn't specifically ask Conoco to sign off, written in a written letter. But we certainly had that discussion, email, and gave them proper notice. So,
okay, perfect. Thank you, Mr. Vermillion.
You're welcome.
Art, excuse me, Madam Chairman, can I do a redirect?
Yes.
Thank you. Art, I want to clarify something you said. The royalty owners weren't notified, were they? It was just the parties that have the either lessees or have the right to drill, unleased owners, working interest owners, in other words. That's correct,
Yes,
right?
yes, that's correct, Fred.
Okay.
Thank
All
you
right.
for
I just want to
clarifying that.
clarify that for the record.
Yeah, thank you for that. I appreciate that.
Yep.
The division has no further questions for this witness.
Okay. Can we move on?
The board members have any questions for this witness?
No questions.
All right. Thank you. Thank you, Mr. Vermillion. You can sign off now.
You're very welcome.
Okay, Madam Chairman, I'll commence my examination of Mr. Snyder. Mr. Snyder, please state your name and business address for the record.
My name is Michael Schneider. My business address is 1000 East 14th Street, Plano, Texas, 75074.
And what is your current position with Urban?
I'm currently employed at Urban as the exploitation manager.
And you have supervisory capacity over the Utah assets?
Yes, sir. I supervise a multidisciplinary team composed of geology and engineering components to fully develop and minimize resource waste across our entire company.
All right. Since this is your first time testifying to the board and the board has your resume, but I'd like you to just provide a brief summary of your education and work experience, especially in the Rockies and anything with coal bed methane, and if you've also been previously recognized as an expert before other state commissions.
Yes, sir. I've been in the oil industry for about 10 years now. I started with my education at A&M Kingsville with a bachelor's, followed up with a master's degree at the University of Texas Permian Basin. In the Rockies in particular, I spent a lot of time in the Paradox Basin developing oil and gas assets. I've previously been recognized as an expert witness in geology in Oklahoma as well as in Nebraska.
All right. With his resume and that testimony, Madam Chairman, I would ask that the board recognize Mr. Snyder as an expert in geology for purposes of this cause.
Any questions or comments? Accepted.
Any objection from the division?
No objection from the division.
Thank you. All right, Mr. Schneider, I'm now going to show you what have been marked, and I apologize this for the board. We're going to go a little bit out of order on the exhibits, but the PowerPoint will be in correct order. Exhibits F through H, K, and substitutes L1 and L3. Do you recognize these documents?
Yes, sir. They were prepared by myself or under my review.
Okay, now turning your attention to Exhibit F, would you please explain to the board what this represents?
It's the purpose of defining the fair and coal interval as utilized in 241.01, 241.04, 241.09 orders.
Okay, now turning your attention to Exhibit G, please explain what this shows.
This is a cross-section across our position in the fair and coal. It establishes lateral continuity of the coal, with the top being the red and the tunic shell being the bottom or the base in the black. We were establishing that the coal underlies sections 14 and 11 and is comprised of coals, carbonaceous shells, sandstones, all of which are reservoirs contributing to the production. The productive capacities or capabilities of this formation is primarily determined by the presence of naturally occurring faults or fractures as butt and face cleats. These will generally increase the ability to move methane through the formation, ultimately leading to the production capacity of the wells.
All right, now turning your attention to Exhibit H, which is a two-page exhibit, starting with H1, please explain what this shows.
This is a structural map on the top of the fair and coal. We're illustrating it dipping to the north. The brighter colors are the shallower colors, and we don't see any major structural elements across the area.
All right, then turning to H2, please explain what this shows.
This is an isopack map of the coal thickness in the area. What we're identifying in this isopack or thickness map is 14, 22, 23, and 11 are in a very well-developed thick area of the coal deposition.
All right, turning your attention to Exhibit K, please explain what this shows.
Exhibit K is showing a graph. It illustrates on the x-axis density as measured from core-derived information. On the y-axis is gas content as its relationship to SCF per ton. What we're doing is we're establishing the relationship between density that we're going to measure in the well logs and gas content, SCF per ton, that we're going to ultimately lead us towards the volumetric estimation.
Okay, turning now to substitute exhibit L1. Please explain what this shows.
L1 is illustrating our determination of gas in place for section 11. We've broken things down on columns for the northwest 160s. For each of the major intervals in here, we have C, CS1, CS2, CS3. These are different rock types based on row B bends. For each of the areas, we've identified the average thickness, the ash content, the SCF per ton. That ultimately leads to the estimation of gas in place by rock type, and then in total at the bottom.
And finally, turning to substitute exhibit L3, please explain what this shows.
Similar to the previous slide in format, we're illustrating how the different rock types are contributing to the areas that are leading us to the volumetric estimations for each 160 in section 14.
Same process that you discussed in the previous exhibit, is that correct?
Yes, sir.
And this just pertains to section 14.
Yes, sir.
All right, Mr. Snyder, is it your expert opinion that the lateral continuity of the reservoir illustrated by the cross sections, structure maps, isopac maps, and the core analysis defining gas content, and the volumetric characterization utilized to calculate the existing well EURs, which Mr. Wade will testify to, the remaining volumes to be produced and the economic parameters support additional infill drilling to prevent resource waste?
Yes, sir.
Madam Chairman, that concludes my examination of Mr. Schneider.
Questions from the board? From the division?
Yes, the division has some questions. Do you want to go first? Okay, you go ahead.
Yeah, Dustin Doucette for the division again. Maybe a question on this exhibit L3, this gas in place calculations. Would that include gas that is being derived from drilling units outside of where the well's located? And maybe if you go to exhibit J, maybe that will help.
That'll be addressed by Mr. Wade.
But hasn't he testified on the gas in place numbers here?
Well, if you feel comfortable answering the question.
What we've done in this particular exhibit is to establish what the total gas in place is. Mr. Wade will testify towards what's been out of the existing wells in it and what remains to be produced.
Okay, so he'll do the actual drainage from each well then. Okay.
Yes, sir.
Maybe just to go to exhibit J real quick, and maybe this isn't a question for you, but let me ask it.
Okay, well, we haven't gotten there yet, but which
let's
exhibit?
try. Exhibit. Oh, maybe I wrote the wrong one down. It was the kind of the isopac,
Okay,
I believe. Yeah.
which one? This one?
The next one.
Okay,
Yeah,
there you go.
right there.
That's exhibit H2 for the record.
H. Okay. So just on this, I mean, are you expecting you have your wells located there, and are you expecting drainage across those boundary lines of those drilling section?
It's difficult to say exactly where the drainage is going to occur at. What we've established this far is we've established what the gas in place is per each of the units. And what I believe Mike Wade will attest to is there is enough sufficient gas in place to be drained off of the current spacing units that we're in.
Okay, and so are the circles just cartoon representations of maybe expected drainage? I don't expect it to be exactly like that, but is that what that is representing on this exhibit?
Those those circles are in reference to a 900-foot circle, or 900-foot. It's an arbitrary 900-foot radius that correlated back to what Mike or Art Vermillion presented on his land maps.
So that would be a drainage
No, sir.
approximate?
Oh, sorry. No, sir. That it's just a 900-foot. We used it to make sure we were spaced at least 900 feet away from existing wells from a land perspective.
Okay, and so that'll probably lead to questions for the next witness. Thank you.
Any further questions? Great, let's move ahead.
None from the board either?
No.
Okay. All right, I'll commence my examination. Mr. Wade? Mr. Wade, would you please state your name and business address for the record?
Yes, my name is Mike. My name is Michael Wade. I work for Urban Oil and Gas based in Plano, Texas. Address 1000 East 14th Street, Plano, Texas 75074.
And what's your current position with Urban?
Chief of Rockies Operations, which handles all the wells in Utah and Wyoming.
Okay, I'm going to show you what have been marked as exhibits I, right here, I, J, I'm just going to whip through these, J 6, 1 through 6, and then corrective J 7 through 12. Substitute L2, L4, and M1, M2, M3, M4. Do you recognize these documents?
I do.
Were they prepared by you or Urban personnel with your review and input?
That is correct.
Okay, turning to Exhibit I, could you point out what this is intended to show to the board?
Yes, this is from a 2011 Advanced Reservoir Engineering book. Most importantly, the thing to note here is we're really talking about the first paragraph up here. The excerpt is just to bring up the point that coal bed methane production, as previously mentioned, it has to be viewed a little bit differently than conventional reservoirs. Because of coal bed methane, the coal absorbs the methane to the rock face. And then to desorb, you have to remove the water. And actually, interference from one well to another actually helps the offset wells, whereas a conventional reservoir, you're taking away from your offsets. But in coal bed methane, removal of the water allows for the desorption from the gas face in the offset wells, which actually increases their recovery.
All right, could you please summarize for the board briefly what was the results of Anadarko's infill pilot that was conducted in 2010?
All three wells proved up reserves with an average of 1.5 BCF per well, which is above all of our economic hurdles.
In other words, it proved up their supposition that infill drilling was needed.
That is correct.
All right. Turning your attention now to Exhibit J, and I'm not going to go through each and one of these. I'm going to turn the attention to J6 and J12. Just briefly outline what do all of these Exhibit Js reflect and the importance of J6 and J12.
Okay. These are all decline curve analysis for each of the wells that are in the current sections that we're looking at. And if you want to actually move back to J5. So this right here is a section 14 type curve. And what you see here is the production coming on. And a couple of years after the production has come on, you see the production increase there. That is because there was field-wide compression that was installed that makes that production bump. So now if you move to, hold on one second. If you see there, the gas EUR for that curve is 3.457 BCF. If you move to the next exhibit, what this is the same EUR here. However, this takes and it removes the compression. So we have just a peak production and it moves down, but we're maintaining the same reserves. This is just this is a type curve just to take account for the compression that was in the field.
And this is the type curve for section 14?
That is correct.
Okay, now let's go to J11 then.
J11, same thing here. This series of wells was drilled a little bit earlier, so you could see how it took many more years to get to the compression. But when the field compression was put in, production moved up. So if we move to the next exhibit, just like the previous, the reserves are the same here for the type curve. However, it's just moving the initial production up to account for the compression.
And exhibits J11 and J12 pertain to section 11, correct?
That is correct.
Okay. Now turning your attention to substitute exhibit L2, would you please explain what this shows?
Yes, what this shows here is where we did our calculations for section 11 for each quarter section to look at the gas in place. And then we didn't come up with it. There was a recovery factor of 80% applied. Most coal bed methane has been documented as an 85% recovery. We're going a little conservative here. And this is showing that the EUR of the existing wells in each section in the northwest quarter section, Total gas in place is 8.4 BCF. 6.7 is the EUR of the existing well, which leaves approximately 218. I'm sorry. I'm sorry. My vision is just a little
Here,
blurry.
let me do this.
This basically shows the remaining gas that is in each quarter to show that we're going to have remaining gas that's going to be there even after our producing wells have hit their limit.
And that's for section 11.
Yes. So the EUR, okay, now that I can actually see this, the EUR there, let's say for the northwest quarter section of 11, the EUR there with that recovery factor is 6.687 BCF. The well that we have in that section has produced 218 million, which leaves 6.5 BCF remaining. And so each quarter section within that unit 11 is detailed out. The recovery for that section minus the well that has been produced and what is remaining in that section.
All right, now turning to substitute exhibit L4, please explain what this shows.
All right, so this is the exact same as the previous exhibit, but this is over section 14 only. We have our gas in place with a recovery factor of 80%, leaving the EUR out there in this section to be recovered. And then we have each EUR of the wells that are in that same section, leaving gas remaining in place that is not going to be recovered.
Absent infill drilling.
Correct.
Okay. Now turning your attention to exhibit M1, please explain what that shows.
What this shows right here is this is our economics for our drilling program. The wells out here costing around $750,000 to drill. Based back on the decline curves and the it's in here drawing a blank. For our base case here is a reserves recovery of 2.5 BCF. The price deck used there was a strip pricing as of 3/29/22, and you can see pretty healthy gas prices. Gas prices have actually moved up approximately $2 an MCF from where these prices are. Drilled at these prices in this reserve, that's a 75% rate of return and a PV10 of 2.5 million.
All right, turning to M2.
So what this case looks here is what kind of reserves would we have to find to be able to break even, maintain that same 750,000 initial cost, and having a PV10 of 0. We need approximately 0.6 BCF
For economic.
to be an economic well.
Okay, and then on M3 and M4, is that the same type of analysis?
This is the same
with
analysis.
Section 14.
This is the same analysis. Section 14, we've got a little bit better coal here, so the reserves are up about a BCF from the prior, which makes our return on investment higher, net present value of 3.6. And then on the next slide, same concept here. We need just a little over 0.6 BCF to make an economic well.
Okay. Can you address why these particular locations, and I'll refer back to going back to the land exhibits real quick. Referring to exhibit D, why were these particular infill well locations chosen?
Okay, if we're going to talk about the well location on 4214, which is on the far east side of section 14, we have a lot of terrain issues over there. Almost taking a direct line from our proposed well up northwest to the well in that section. Almost that entire northeast side of that is coming off of a hillside. If you look over there in section 13 to the right of section 14, you see what looks like an X. That's actually an airport. And so the airport is up on a high hill, and as it comes off from section 13 and it almost ends there in section 14, we will never probably be able to drill a well on section 13, even though we have leases over there based on terrain and the airport. And so we are putting this location, and then on the southeast quarter of the southeast quarter, there is a public dump there. And so they'll never be able to put another well down there in the south on that southeast quarter. So we're picking a location that basically we're looking at as the last location we can drill over there to develop any reserves based on terrain and the airport and the dump. And then on the section 2214 well that's right there in the middle, That well, again, is an issue where we're having terrain issues. The location is actually picked at a high point, and then based on common ownership in all 4 sections around it, we thought that was a pretty ideal location to try to stay optimally as far away from offset wells while maintaining being able to handle all the terrain.
Okay, and then if the 3322,
The 3322, it's up there, the Helper State well, with us having common ownership around everywhere and terrain. Again, we're trying to maximize our distance from offset wells while adding an additional infill well.
okay, wait a minute, that you're referring to the Helper State one. I'm talking about the one
Oh,
in
I'm sorry.
22.
I'm sorry, you're down here.
Mhm.
Yes, that is because that location is being picked because we are down in an area of farmland and we're on an area of creeks and right around some houses. And so our location there is really being boxed in by both terrain and by buildings. We have setbacks that we have to stay away from farm buildings, houses, and we're getting boxed into a small corner down in there.
All right, so then is it your expert opinion that one well per 160 acre drilling unit will not recover all the gas, thereby committing waste by leaving resource in the ground?
That is correct.
Is it also your expert opinion that infill drilling is therefore required?
That is correct.
Is it also your expert opinion that the proposed wells are at locations to optimize interference and recovery and due to other practical factors to which you testified?
That is correct.
And finally, is it your expert opinion that the infill wells will be economic?
That is correct.
Madam Chairman, that concludes my examination of Mr. Wade.
Yeah, the division has a few questions, Mr. Wade, and these questions are probably going to be kind of follow-up from previous questions asked by the previous witness, Mr. Schneider. Will urban be draining from areas in DSUs outside of the DSU where the wells will be located?
Due to the heterogeneity nature of the coals, there is a possibility of that. However, in each section, we have shown that there are more than enough recoverable reserves to satisfy our wells.
Okay. And can you identify which wells could potentially cause such drainage?
The wells in section 14, both wells could potentially drain offset. The Leota well could potentially drain offset based on its location.
And then how far beyond the section or DSU line would you anticipate potential drainage from these wells?
As shown on the ISOPAC maps, there is a lot of heterogeneity out here with the coals. And so while I don't have specifics on that, it would take a 12 to 15 acre drainage radius to be able to meet our economic hurdles.
And then do you plan on sharing with parties whose interests are in another DSU or section, but could potentially be drained by these wells?
We have gone through the legal procedures to notify the partners and our partners to notify those offset interest owners and to also speak to them as Art testified beforehand. And as far as we were looking, we felt that satisfied this issue.
Perfect. Thank you, Mr. Wade. And division staff has a few follow-up questions from these.
Yeah, Dane Doucette with the division. I just have one follow-up question based on something Trevor asked. If we could look at Exhibit E2. So if I heard you right, I believe you stated that this well could drain outside of the spacing unit it is in, correct?
This is the 40 or the 2214.
That is correct.
And so
However, it's common ownership.
would
That is correct. It could drain offset. However, there is common ownership in all 4 160s surrounding that, or all 4 40-acre units surrounding that well.
but is there common ownership in all 4 drilling units in that section?
No.
Okay. So my final question is, so do you feel correlative rights are being protected, placing a well basically at the intersection of 4 drilling and spacing units and only sharing with one of those drilling and spacing units?
If I may answer part of that, Dean, the north half and the southwest quarter are all common under a federal lease. So
Okay.
all that's the same. The
Right.
only drilling unit that, based on Mr. Vermillion's testimony, that changes is the east half southwest. And Urban does have a lease in there, but it's commonly shared with ConocoPhillips and Buzzard Bend.
But the drilling unit is the entire southeast quarter,
Right,
correct?
understood. So it'd be the southeast quarter that you're asking your question about.
Correct.
Yeah.
Yes.
What's wrong here? So he's asking, since this is ConocoPhillips, so he's saying, would this drilling unit be drained?
There is the potential, correct.
No further questions from myself. Yeah, Destin Doucette with the division. I just got a couple of follow-up questions, and maybe on a follow-up to the question that was just asked. You had mentioned for your reserves and for these to be economic, you had to drain 12 to 15 acres. What kind of radius of drainage are you talking about on that?
I'd like to refer that question to our geologist. Is that okay?
Here, Michael, why don't you come up here?
May I have an opportunity to consult real quick? All right. Okay, thank you. As Mike Wade attested to, we're going to need about 12 to 15 acres, depending on what thickness of coal we identify with or intersect with the new drill well to attain a economic well. To meet his type curve wells, we're looking at somewhere in the order of 54 to 58 type drainage area. Now, how that area is described aerially is difficult to draw on a map, but those are the volumetrics that are required.
You're saying 54 feet?
54 acres.
54 acres. But what does that equate to in lateral, based off the thickness of your coal, et cetera? I'm asking how far do you think that's going to drain?
I'd have to go back and calculate it. The 54 acres represents a polygon around the well and how far it had to reach out and the volumetrics that would be required in order to meet its type curve or the economic expectations.
And maybe I do have another question that maybe will help answer this a little bit more or clarify this a little bit more. And I don't know if you can answer this or not, but maybe to go to Exhibit H1 again, just for a visual reference. I know the testimony was that based off of, coal bed methane, you wanted interference between wells, correct?
Yes, sir. That would be ideal.
So are these being located, aside from, the topography issues that have been testified to, generally equidistant from existing wells to accomplish that interference so you can get the water off, so you can desorb the gas from the coal and produce the gas to the wellbore?
As Mike Wade, I pull in everybody's testimonies together. The circles represented here represent a 900-foot radius around that. That's a radius that we have to stay away from way away from existing wells. We did that in conjunction with our limitations on the topography extent as well to make sure that boxes into corners. We've looked at several different realizations of being able to move these around, and these have been the ideal locations to stay from that 900 feet away and minimize our surface disturbance.
Yeah, maybe this is for Mr. Wade, this question, but my question is more about the location of the wells in relation to interference to pull the water off to better drain and desorb the gas from the coal.
These locations are as optimal as we can get in the field, given our current terrain and given the equidistant distance from the existing wells. On the east half of section 14, we're approximately 2,100 feet from the well in the northeast quarter section, and we're approximately 1,900 feet from the well in the on the 4214 on the far east side. We're approximately 1,900 feet from the well that is within that section and 2,100 feet from the well that is in the southeast section there.
If it helps
So-
the board and Mr. Doucette, is Exhibit D shows the existing wells in relation to the proposed wells, and you can see where the locations are in relation to those existing wells.
And then to answer your question earlier, the 54 acres, that's a 865-foot radius.
So it would drain across the drilling unit boundaries then?
Potentially, yes.
How far are you away from the drilling unit boundaries? I think it's in the exhibits, but maybe if you could clarify that. So there's not this doubt.
I think it's like 290 or it's under 300. I know that. I don't have the official setback on this. 2635. To do some math real quick here.
1 and 14, the 2 and 14 are the bigger ones. Okay, 249 feet.
Yeah, they're
if you look at Exhibit 3
They're approximately 250 feet from the lease line.
for the Section 14 wells. And then the Leotode is 113
Yeah, the
feet.
Leota is 113 feet away from the lease line.
Leota, excuse me. So if you look at exhibits E2, E3, and E4, that's where those boundary distances are.
Correct. So I guess it would be considerably less than 800 and some feet that you stated would be draining to make it economic.
If we were taken as a full circle, correct.
I think that's all the questions I have. Thanks.
Any
No.
further questions from the division?
No, the division has no further questions for the witnesses and would like to thank Mr. Schneider, Vermillion, and Wade for their testimony today, which has been really helpful.
Board?
Just a quick question. In the notification that you sent to others, was it very clear about potential impacts to what their holdings were?
If I may answer that, the notice was sent out, as far as Mr. Vermillion testified, he notified ConocoPhillips and Buzzards Bench of the locations. And as far as the request, which outlines exactly what we're doing here and what would be done, it was sent out and it doesn't specifically state you're going to be drained or, it may be impacted. It's the notification of what was requested exactly as has been testified.
Mr. Church?
Yes, question for the division. What in your minds would be a step to be taken to protect correlative rights here of the people that would be drained? What would be the options for protection of correlative rights?
Yeah, under the setback rules, specifically Utah Admin Code R6493-3 says that whenever an exception location is granted, the board may take such action as will offset any advantage that the person securing the exception may obtain over other producers by reason of the exception location. So the division would recommend potentially requiring sharing across the DSUs and section lines to take place if the request was granted. And Mr. Doucette would also like to make a comment if it's appropriate, Madam Chairman.
Yeah, Mr. Church, I would just say, I think we've kind of set, I don't want to say set precedents, but the way we've handled it, like in the 2560 drilling units, they're drilling those barely in one 1280 drilling and spacing unit, right? But they're sharing with both of those. So that's how it's been handled in the past. And to me, this is a similar situation. I mean, I know it's horizontal versus vertical well, but it's still a similar type thing. When when we drill right up against a drilling and spacing unit boundary, they share between the two drilling and spacing units is how it's been done in previous spacings in the horizontal with the horizontal wells.
Thank you.
Could I ask, and maybe you've covered this, down in the quarter sections where the 1323, I'm not even going to try the name, and the 3322, are those 160s? Are each one of them common ownership? Like is the one quarter one ownership and the other one? I'm trying to determine if there is mixed ownership here, and is all of the interest leased?
If I can summarize Mr. Vermillion, I'm sorry he left. I excused him and I probably shouldn't have. But his testimony. Oh, Art, you're still there. Good.
I'm still here.
Did you hear Ms. Garrison's question?
I did.
Okay, could you answer that, please?
Yes, in the southeast quarter of section 22, we have 100% of the east half of the southeast quarter fully leased, and common ownership is urban oil and gas completely. In the west half of the southeast quarter of 22, we're currently at 86.25% leased. That west half of the southeast quarter falls inside the city limits of Price. So we have some chopped up acreage that we're trying to lease in the northwest of the east half of the southeast quarter. So that represents that small little percentage that we do not have currently leased. But that puts us at over 93, 94% leased for that entire quarter section. In a perfect world, I'd have everybody leased up, right away, but it just takes a little time with some of these people. But they've all been, very nice to work with. It's been a great project to be working on. In section 23 in the southwest quarter, the west half of the southwest quarter, we have fully leased 100%, and it's all owned by urban oil and gas. In the northeast quarter of the southwest quarter is leased to urban 100%. And then in the southeast of the southwest quarter, we have that leased at 90% of that 40-acre tract, and the remaining 10% are the three people that we made reference to that were given proper notice, and we are continuing to try to lease those three remaining interests as well. So our position in both the southeast quarter of 22 and the southwest quarter of 23 is substantial, and it is all owned by urban oil and gas.
But you still have outstanding unleased interest, is that correct?
We do very, very small amount. Yes, ma'am, we do.
And are you going to force pool those interests, or what are your plans for the unleased interests?
Our plan right now is to lease them. If we had to go to a forced pooling process, we would. But typically, when we've dealt with other unleased mineral owners out here before, when we go to that process, they ultimately will lease with us. So we anticipate all of them, to lease. That's just a positive I take when I go out there and try to put together, the ownership in these spacing units. So I'd expect that they ultimately will be leased. If not, we would give them, under the forced pooling process, the opportunity to participate in the well, provide them a JOA and an AFE, or lease them or force pool them.
Thank you. Any further questions from the division?
No further questions from the division.
Board members, do you have any additional questions?
Just a general question again. Since we, as you mentioned, Mr. McDonald, haven't dealt with coal bed methane, these wells have approximately a 30-year life. Is that what you anticipate?
Actually, most of them at least 30 years, correct.
At least 30 years.
Yeah.
And when you dewater these, does it dewater? So each new well has a dewater phase that they have to go through before the gas begins to produce?
Yes, it generally takes 4 to 6 months before you reach your peak production. And you'll see that on the type curves. You'll see starting gas at 0. It takes 6 months to get up before you get to your max production. That is correct.
Okay.
The gas will not desorb off of the coal face until the water and pressure has been removed.
And then on the curves that you showed earlier, then you go in and repressurize or
No, the coal bed, the methane is absorbed onto the coal face, and as you remove the water, that removes the pressure and allows the methane to desorb off of the face and be produced. And you just continue to try to dewater the coal bed methane over the entire life. Every single well out there is on pumping unit. And throughout the entire life of the well, you're continuing to pump the entire time, trying to remove that water. And actually, this Farron coal and the sandstones outcrop approximately 15 miles away. And so you get a constant feed in from rain, snow, and everything else working its way through gravity down, which is why we can't just dewater it and be done with it. It's not a closed container.
but you said that each well actually beneficially helps adjoining wells by
Yes, that is correct. Because with the water removal, that allows the desorption of the gas in the offset wells by having less pressure in that reservoir. We've actually noticed numerous wells in our field that if one of the wells goes offline and it's a large water producer, you actually start to see the offsets decreasing in production because of the water not being removed.
Okay, thanks for that overview.
Do we have any further questions? Mr. McDonald, would you like to summarize here?
Yes, thank you, Madam Chairman. Let's do some housekeeping first. I'd like to move for admission of exhibits A through J6 inclusive, corrective exhibits J7 through J12, exhibit K, substitute exhibits L1 through L4, and exhibits M 1 through 4, and Z is supplemented.
In my packet, I do have a J13.
That was a mistake. That was I misnumbered initially. It was J6 and then it went to J8 to 13.
Okay.
That was the correction that we made. And at this point, Madam Chairman, I would like to reserve rebuttal time after the division has made its closing statement.
Thank you. Division?
Division staff have met regularly to discuss petitioner's current request. The division supports the science and engineering leading to the request and believes such spacing will promote efficient extraction of the resource. The division engaged in an open dialogue with petitioner, seeking clarification on a few parts of the RAA, including correspondence just days prior to this hearing. The division did not file an opposition to petitioner's request because of the open dialogue and collaboration. However, the division is concerned with correlative rights and the contemplated wells' potential to drain from areas outside of their DSUs without appropriately compensating the corresponding owners. The division points to a relevant example that has recently received broad attention from the board. When establishing spacing units for 2560s, the board requires companies that drill near the boundaries of the adjacent 1280s to share on the entire 2560 to account for the drainage that occurs beyond the DSU boundary. Here, petitioner is similarly draining beyond the 160-acre DSU, but petitioner is not sharing with the adjacent 160s. Petitioner suggested that because the adjacent owners did not object to the RA, petitioner is entitled to an exception location, and that adjacent owners can protect themselves by drilling and offsetting units being drained. However, the division notes that drilling unnecessary wells to protect one's rights constitutes waste, as that term is defined in the Conservation Act. Rather, the division encourages the board to use tools already available to it, specifically Utah Admin Rule R649 3-3 states that whenever an exception location is granted, the board may take such action as will offset any advantage to that person securing the exception may obtain over other producers by reason of the exception location. The division encourages the board to require petitioner to share with the adjacent 160s when the DSUs are being drained as a result of the exception location, similar to what the board has done requiring boundary line wells to share with the 2560 rather than the 1280 upon which it is located. Thank you.
Rebuttal.
Thank you. Members of the board, contrary to what is being stated here, correlative rights have been protected by this very process. Exception locations by their very nature involve wells that are to be located outside of a setback that was set in place to protect possible drainage. Due process and correlative rights are protected because notice and an opportunity to object are provided. If a party believes that their correlative rights are being adversely affected, they have the opportunity to object. If they don't, they either have waived that opportunity or otherwise believe that they are not being disadvantaged. Here, all of the parties, including such sophisticated oil and gas parties as ConocoPhillips and the BLM, were provided notice both before and after the request was filed, and they haven't objected. They haven't expressed any concerns. The regulation cited by Trevor states that the board may, permissively, take action as will offset any advantage to the party seeking an exception, excuse me, seeking an exception location that may be obtained over others and advantage over the others. However, who's really disadvantaged here? They've been given notice and they haven't objected. Furthermore, nothing prohibits those parties to petition the board at a later date if and when they ever do, in fact, feel that they have been disadvantaged. What the division requests is actually creating special drilling units for each of these particular wells rather than infill drilling, which is what the petitioners requested. Since Section 11 is covered by one state lease in which there is common ownership, correlative rights are not adversely affected. There's no question about Section 11. As to the other wells, such actions will require additional contracts to be executed and approved, including communitization agreements and joint operating agreements for each of them. And for the reasons I am articulating, that is time-consuming and unnecessary. I want to conclude by saying that statements made by the Utah Supreme Court in the 2002 case, Hagerty versus Board of Oil, Gas, and Mining, are very instructive to the board on this issue. That case involved a situation where a landowner was not entitled to retroactively pool into production to data first production until he took the action to seek spacing some 7 years later. In support of that decision, the quote stated, and I quote, "Landowners knew of their correlative rights or at least had notice to inquire after them. Here, the landowner's inaction was wholly voluntary. And most importantly, they stated, a good law, like a good parent, does nothing for a person that he or she can't do independently." We followed the exception location. We've brought the action in front of the board. It's been noticed. Everybody had their opportunity, and there's been no objections to this. If they believe that their rights were adversely affected, they could have objected, or in the future, under this regulation he cited, they can come in front of the board and petition to allocate on a sharing situation. Either way, their correlative rights have been protected by the process here. Consequently, we ask the board to adopt and grant the RAA as submitted, and we thank you for your time and attention on this matter.
Thank you. Can we step back just 1 second, Mr. McDonald, because I don't think we formally accepted your exhibits.
Oh, okay, yes.
I want to go ahead
if
and
it's
do
on the
that.
record, if that's okay.
Yes.
Okay, thank you.
Division, do you have any further comments?
No further comments from the division.
Board, do you have any comments?
We need to discuss this.
Yeah, I was just going to say, would you like to retire and discuss this? And we'll be back in a few minutes with our decision. Thank you. We're going to go back on the record. Do I hear a motion from the board on this petition?
Madam Chair, I make the motion that we approve the request by Urban as requested.
Do I hear a second? It's been moved and seconded. Any further discussion or comments? Vote? I think just a verbal aye.
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 Thank you. The motion has carried. Mr. McDonald, would you please prepare the order?
Certainly. Thank you, Madam Chairman.
Thank you. We are going to move right on to the next item. Are you ready, Mr. McDonald? Next docket item is docket number 2022-008 in the matter of the request for agency action of Uinta Wax Operating LLC. Would you like to commence?
Appearance of counsel. Yeah,
Appearance of counsel.
Fred McDonald of Counsel of Lear and Lear on behalf of Uinta Wax Operating LLC.
Thank you.
Trevor Gruel, Assistant Attorney General on behalf of the Division of Oil, Gas, and Mining.
Thank you.
With me today, members of the board are Mr. Zachary Archer, landman of Uinta Wax LLC, Shay Atkins, who's the geology manager of Finley Resources and Uinta Wax LLC, and Ms. Kayleen Tovar, who's the senior reservoir engineer for Uinta Wax LLC. All share the duties with the petitioner, and I would ask that they be sworn in as witnesses at this time.
Will you please raise your right hands? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Members of the board, the resumes of all the witnesses were collectively submitted as Exhibit A. If asked, each would confirm the information reflected in the respective resumes is true and correct. Mr. Archer will be a fact witness only. Mr. Atkins has been on many previously occasions recognized by the board as an expert in geology, and Ms. Tovar has been previously recognized by the board as an expert in both petroleum and reservoir engineering. Presuming the division has no objection, we ask the board recognize them as experts in geology and petroleum engineering respectively for purposes of this hearing.
So
The division does not object to this.
recognized.
Thank you. I also want to confirm that the board received the revised Exhibit O that was filed last Friday in this cause.
I have a- Wait a minute, is this it? Yes,
Thank you. Also, Madam Chairman, just to confirm that it's acceptable to move for admission of my exhibits at the end of our presentation in chief.
yes, that's fine.
Thank you. Members of the board, Uinta Wax is today seeking approval from the board of several measures which will allow development of the Lower Green River Wasatch Formation in the Bridgeland Lake Canyon areas via long lateral horizontal wells. This will require the board to grant the following relief. First, Uinta Wax requests the board to vacate the order in cause number 131-151 as relating to Section 5 of Township 4 South, Range 5 West. The drilling units for long lateral horizontal wells established under that order were off pattern because Section 1 of that township was not addressed in that order. As no long lateral horizontal wells have been drilled through the drilling unit that was established, including Section 5, the vacating of the order does not create any prejudice. Secondly, UNWAX requests the board modify and extend the 139-151 order to create the laydown and stand-up drilling units as outlined in the request for agency action throughout townships 4 South, ranges 4 and 5 West. And also to reduce the heel toe drilling unit setbacks from 330 feet to 100 feet as to certain of the drilling units, and the perpendicular drilling unit setbacks from 560 feet to 330 feet. As the board is aware, this is now the trend in the Uinta Basin based on many long lateral horizontal wells drilled to date. Mr. Atkins and Ms. Tovar will be addressing the technical justifications for those setbacks and the drilling unit orientations. These actions will also require the board to partially vacate its orders in cause numbers 139.8, 139.42, 139.90, and 139.107, which cover a portion of these lands to the extent it's inconsistent with the relief requested. True and correct copies of the 139.90, 139.107, and 131.151 orders, 139.151 orders were collectively submitted as Exhibit B. Finally, UNWAX is asking the board to establish overlapping 2,560-acre drilling units comprised of the adjacent 1,280-acre drilling units to allow up to 3 drilling unit boundary wells, similar to what the board previously authorized, including a 100-foot buffer on either side of the boundary line, and that concurrent drilling may occur with wells on each of the 200 and 1,200 acre, concurrently drill on each of the 200 and 1,280-acre drilling units comprising this 2,560 drilling unit, but with the requirement that the 2 adjacent drilling units have a producing well on it prior to the production of the drilling unit boundary well. This is very similar to what you heard recently with UNWAX in cause number 47004. It's important to emphasize here that no boundary wells are going to be requested along the boundary lines with drilling units that have different orientation. In other words, there won't be any drilling unit boundary wells where you have a stand-up and a lay-down boundary. And as to the stand-up drilling units along that transitional boundary, as you will hear, UNWAX desires to maintain a 330-foot heel-toe setback along the northern boundary of those stand-up units to alleviate that problem with the transition. I also want to eliminate any confusion that may have been raised by the drafting of the response, or by the response filed in this cause and the drafting of the request. I want to make sure you understand the UNWAX is only asking for drilling unit establishment and modifications for long lateral wells only. Existing spacing orders and the general spacing rule as applicable to vertical, directionally drilled, or short lateral horizontal wells will stay the same. We're just dealing with long lateral horizontal wells. The board has jurisdiction over this matter pursuant to Utah Code Annotated Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners in the requested drilling units, to all the working interest owners, including unleased interest owners, and the established drilling units, or if unspaced, the quarter sections adjacent to the requested drilling units due to the setback reductions. Notice was also sent to the BIA, the BLM, and SITLA, being the governmental agencies having oil and gas jurisdiction over many of the lands. Those mailings were sent to the parties at their last addresses disclosed by the relevant agency records. The record will also reflect notice was duly published in the Deseret News on April 1st, 2022, Salt Lake Tribune on April 3rd, 2022, and the Uinta Basin Standard on April 6th. On April 11, 2022, Berry Petroleum Company, LLC, a working interest owner in the areas to the south of the requested area, filed a response. However, UNWAX and Berry reached an agreement, and Berry has withdrawn its response. As part of that agreement, UNWAX stipulates and agrees on the record that presuming the board grants this request, the conforming order shall include the same reporting requirements to the board as contained in paragraphs 21 and 22 of the 139-151 order as relating to long lateral horizontal development. The division elected not to file a staff memorandum, and there's been no other objections or appearances with respect to the request for agency action. With that, I'll commence my examination of Mr. Archer. Mr. Archer, please state your name and address, business address for the record.
It's Uinta Wax, LLC, 5128 Apache Plume Road, Fort Worth, Texas, 76109.
And what is your current position with UNWAX?
I'm a senior landman with joint supervision over this area.
Okay, could you please provide the corporate and bonding status of Ueno Wax Operating LLC?
We're a Delaware Limited Liability Corporation in good standing with its principal place of business in Fort Worth, Texas. It is the successor by name change to CH4 Finley Operating LLC as of August 1st, 2021.
And what is the bonding status?
We are authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. We are the designated operator on behalf of Untitled Wax LLC.
Okay, Mr. Archer, I'm going to direct your attention to what have been marked as Exhibits C through L for purposes of this hearing. Do you recognize these documents?
Yes, sir.
Were they prepared by you or Ueno Wax personnel with your input and review?
Yes, sir.
Turning your attention to Exhibit C, would you please explain to the board what this shows?
This is a regional locator map. This is just identifying the area that we intend to space during this application.
And that includes a portion of the town of Duchesne?
Yes, sir.
Excuse me. Turning your attention now to Exhibit D, please explain to the board what this shows.
So these are the application lands of the spacing of they're showing the 1,280 acre DSUs in their relative orientation. I'll call your attention to what Fred was discussing earlier. It's the yellow-orange yellow-orange boundary. That's the transition zone. That's where we would be maintaining that 330-foot heel-toe setback from those northern stand-up DSUs.
And that's also where you're not asking for any drilling unit boundary wells to be located.
Correct.
All right. What is the ownership here of these respective drilling units? In other words, does Ueno Wax or do Ueno Wax operating under a joint operating agreement own the majority interest?
Yes, we own the majority interest of all these sections or have support of, with the exception of sections 1 and 2 sections 5 and 6 of 4 South 4 West, sections 1 and 2, and sections 14 and 23 and 15 and 22 of 4 South 5 West.
And what's your intention with respect to those drilling units? In other words, securing the control?
Yes, we will, prior to proposing wells on those, we will secure control of more than 50%.
Which is required under the regulation.
Correct.
Excuse me. Turning now to Exhibit E, please explain to the board what this shows.
So these are the existing spacing orders. The green hatched area is subject to RA 13990. Section 1 is subject to RA 13908, 13942, and 13983. The blue hatched area is subject to RA 131-107. The white area is currently unspaced and on field-wide state rules. The yellow hatched area is subject to 131-151, and it's the only order currently addressing long lateral horizontals. It allows for 12 long lateral horizontal wells on 1,280 acre DSUs. The DSUs are all lay down orientation, and they have a 330 east-west setback with a 560 heel-toe setback.
All right, just to clarify, it's the 139-107, excuse me, and 139-151. Those are typos on my part. Okay, turning your attention now to Exhibit F. Please explain to the board what this shows.
Okay, so this is the offset spacing. We've got offset is the gold hatched area is the existing 139-151 area, which is operated by Uinta Wax operating. The green hatched area is subject to RA 139, 151, 139, 155, and 130.05. Those areas are operated by EP Energy. It has variable orientations and setbacks with overlapping 1,256 acre drilling unit boundary wells. The blue hatched area is what was recently spaced by Oventive, and it's subject to RA 130.07. And they've got 560 foot setback east-west and 330 heel-toe setbacks.
All right, and those all pertain to the long lateral horizontal wells.
Correct.
Okay. Now turning your attention to Exhibit G, please explain to the board what this shows.
These are the requested, or these are the proposed DSUs under the application. It reflects their orientation of lay down and stand up.
And I'll note for the board that this shows some existing wells and all that, but that'll be addressed in an additional exhibit. Now turning your attention to Exhibit H, please explain to what this shows.
So this is showing the internal 2560 overlap DSUs within the application lands.
Can I again point out the transition zone? What is the intent with the north setbacks there?
We will stay 330 feet off of that northern line.
And no drilling unit boundary wells in that area.
Correct.
Okay. Then turning to Exhibit I, what does this show?
This shows the 9 external 2560 acre DSU boundaries or overlap DSUs. Same thing with transition zone 330 and no boundary line wells on the transition zone.
Finally, on Exhibit J here, what does this show?
This shows the combined external and internal 2560 overlap DSUs.
All right, now turning to Exhibit K, please explain to the board what this shows.
This is just the application lands and all of the existing wells contained within those application lands.
And there has been no long lateral horizontal wells drilled yet?
No, sir.
Now turning your attention to Exhibit L, please explain to the board what this shows.
So this is the notice area that we sent out, and which we provided notice to all interest owners in the red, all working interest owners and production interest owners in red. In the yellow outline area, we provided notice to all working interest owners, including unleased owners within that area.
All right, now I'm going to show you what have been marked, what are the original and supplemental certificates of mailing. These are pleadings that were prepared by my office and are on file with this record. There's a bunch of names shown on there. Do you recognize those names?
Yes, sir.
And who are those parties
Those are the parties that we notified under this application.
that are shown on Exhibit L?
They're shown on Exhibit L.
Okay, and how are those names and addresses compiled?
They were compiled from our internal land records, title opinions, searches of the BIA, Sittler records, Duchesne County public record or county records, and they were all done under my supervision.
Okay. Madam Chairman, that concludes my examination of Mr. Archer.
Thank you. Division questions?
The division has a couple of questions. Is it appropriate for division staff to ask these questions directly, Madam Chairman?
I think so, yeah.
Perfect, thank you.
Dane Doucette with the division. A question. So I don't recall seeing it in your request. Do you have any required offset from new horizontal wells to existing vertical wells?
Yeah, the 130, I'll answer that. The 139-151 order expressly provides for a 330 setback, and that's the adoption that they want to have here.
So are there any vertical wells in currently unspaced areas within the application land or application lands?
All those areas are unspaced.
Yeah.
If you go to Exhibit E, all the white area is unspaced. That's under general well siting.
Right. And are there any existing vertical wells in that area?
Yes.
It appears, yeah.
It appears there are, yes, sir.
So would there be any offsets between any new horizontal wells that you drill in that area to those verticals?
It would be adopting the 330 setback from the 139-151.
Okay. So that the spacing as it relates to, I guess, vertical or short lateral horizontal will be extended from that order into these lands?
No, that's what we're trying to avoid is because of differing ownership. Is that correct? Like Barry's situation, they may own the majority working interest in a 640 as opposed to the 1280 for the long lateral.
So you're saying internally you'll adopt the offset from that spacing order for your horizontal well?
Correct. That's what the request asks for.
Okay.
No further questions.
Thank you.
Mr. Atkins, would you state your name and business address for the record?
My name is Shay Atkins. Business address is 5128 Apache Plume Road in Fort Worth, Texas, 76109, and I'm currently the geology manager for UNOX.
All right, I'm going to show you what have been marked as exhibits M, N, revised O, P, P, Q, R, S, T, and U1 and U2. Do you recognize those exhibits?
Yes, I do.
Were they prepared by you or UNOWACS personnel with your supervision and review?
Yes.
Okay, turning to Exhibit M, would you please explain to the board what this shows?
Exhibit M is the Brotherson 1-11-B4 type log that has been previously used to define the Lower Green River and Wasatch formations, specifically in order 139-151. And I'd also like to call your attention on here to the definition of the Upper Green River, the Lower Green River, and Wasatch formations outlined with the TGR3 and Wasatch going forward to the next slide.
All right, turning your attention to Exhibit N, please explain what this shows.
And so Exhibit N is a cross section zooming in to specifically focused on between the TGR3 Lower Green River formation and the Wasatch in a cross section across the application lands that you can see on the locator map on the bottom left. There's 4 wells. You can see on the left side of the cross section identifying the Upper Green River, the Lower Green River, and the Wasatch. And on the right side, calling out the current development model that we see being horizontal development in the deeper formations, Castle Peak, Uteland Butte, and Wasatch, and vertical development in the shallower formations. Although we do see potential opportunity for horizontal development in the shallower formations as well.
So it's UNOWACS Operating's intent not to preclude horizontal development in those upper zones?
That is correct. And it is our belief also that this constitutes one common source of supply in this area.
Now, turning your attention to revised Exhibit O, please explain the significance of this exhibit.
So Exhibit O, there's a lot going on here, and we'll carry some of this information forward into the future exhibits. So starting at the top, there is a table here outlining 6 horizontal wells that UNOWACS has microseismic data for in 2 project areas, but a total of 6 wells. You can see outlining the fracture half length of project area 1, and then the fracture half length, in area 1 and area 2, and then projects 1, 2, and 3 in each. And so the average fracture half length in area 1 is 252 feet, and the average fracture half length in area 2 is 239 feet. And so going forward, with a little bit of conservatism, we'll carry forward the 252 feet. So moving to the map, you can see the application lands, and also want to call your attention to the stress transition zone. And so on the east side of the map, you can see stress orientation data points in a general east-west direction that average north 85 degrees west. But as you move to the west and on the north side of the application lands, you can see those stress data points shift to a north-south direction in approximately north 5-degree west average. So also calling out across the middle of the application lands is the Duchesne Fault Zone running in the east-west direction, and also 2 data points highlighted with green arrows inside the application lands. And so the stress analysis of these wells indicates equal stresses in all directions. So there's no anisotropy identified. And so therefore, horizontal wells could be drilled in either direction to maximize the fracture half length. And so going back to what Mr. Archer outlined with the orientation of the proposed DSUs shifting from north-south to east-west, so stand-ups to laydowns across this transition zone, because we believe it's best to intersect the Duchesne Fault Zone perpendicularly. And then as we transition to the northern DSUs, we have data suggest that these wells need to be laydowns. And so that's kind of the data supporting our orientation of DSUs, and then also why we're calling out this stress transition zone for restricting a DSU boundary well and keeping the 330-foot setbacks.
Now, turning your attention to Exhibit P, please explain what this shows.
So Exhibit P is the current spacing of Order 139-151, covering part of the application lands. And as you can see, with 560-foot setbacks in the east-west direction and 330-foot setbacks of the heel-toe directions, there'd be considerable waste of undercovered hydrocarbon.
Now, turning to Exhibit Q, please explain what this shows.
So starting with Exhibit Q, we apply the fracture half length distances and also the stress orientation numbers that we talked about previously. And so this is a depiction of a stand-up horizontal well in the heel toe direction, showing with the 252-foot half length at north 85 degrees west, with a 100-foot heel toe setback. You would have 78 feet of distance to the DSU boundary. So still protecting correlative rights in that direction.
Now Exhibit R, please explain what this shows.
So Exhibit R is the same orientation for a stand-up horizontal DSU, but looking at the east-west offset, so at the end of the fracture tip, and showing the 330-foot setback would still yield 79 feet to the edge of the DSU boundary. So in this scenario, we're increasing recovery and still protecting correlative rights.
Now turning to Exhibit S, please explain what this shows.
So Exhibit S is a depiction of the laydown DSUs on the north end of the application lands and applying the stress direction and fracture half length to that direction. So it's just a visual to show that basically the math is the same using the stress data and the fracture half length, just applying to a laydown horizontal well. So it becomes the other end of the triangle, right? The angle. So it's 5 degrees, north 5 degrees. And you still show from the toe side of the well in a laydown situation to have 78 feet of distance to the boundary.
Now turning to Exhibit T, please explain what this shows.
So Exhibit T is looking at the same orientation of a laydown horizontal well at the end of the fracture tip, showing the 79 feet of distance to the boundary in this direction. So the same thing, we're reducing the setback, so we're increasing recovery, but we believe we're still protecting correlative rights with our fracture half lengths.
Now turning to Exhibit U1, please explain what this shows.
So Exhibit U1 is a hypothetical scenario looking at just assuring that we're protecting correlative rights across this transition zone. So we know across this transition zone, we're shifting from lay down to stand up. So this assumes kind of the maximum impact that would have during that shift at 45 degrees. And so at 45 degree angle along that boundary, we're requesting to keep the setbacks at 330 feet. And so you can see at the toe side or heel of one of those wells with 330-foot setbacks, we would still have 152 feet of distance to the boundary. So there's a little bit of room for some conservatism to make sure that we're still protecting correlative rights in an area that we know we're having some shift in our stress direction.
And Exhibit U2, please explain what that shows.
And Exhibit U2 is applying the same math in the perpendicular to the wellbore and showing the 330-foot setbacks with a 45-degree angle still yields 152 feet of distance. And so we believe that this is a worst-case scenario or a conservative scenario. So we're still protecting correlative rights, but we're definitely increasing recovery across that known stress transition zone.
Is it your expert opinion then that the Lower Green River Wasatch constitutes one common source of supply in this area?
Yes.
Is it also your expert opinion that uniformity and thickness make the Lower Green River Wasatch an attractive target for longer lateral horizontal drilling?
Yes.
Is it also your expert opinion that the stressed orientation supports both laydown and stand-up units as requested?
Yes, it is.
And that the Duchesne faults as outlined support the stand-up DSU orientations?
Yes.
Finally, is it your expert opinion that the actual basin data supports reduction of setbacks to recover additional resource without adversely affecting adjacent lands?
Yes, it does.
Madam Chairman, that concludes my examination. Mr. Atkins.
Thank you. Division, do you have questions?
No questions from the division.
Okay, please go ahead.
Board have any
Oh,
questions?
I'm sorry. Mr. Church.
Yes, Ms. Atkins, on the common sources supply we're talking about here, do we have both black wax and yellow wax crudes produced here in this area?
Well, there are. We haven't drilled any long lateral horizontal wells, but there are, I think, multiple crudes produced in this area.
Okay, with the black wax is generally in the shallower zones.
Correct. Yes, sir.
So you don't know whether the black wax actually comes out of the lower Green River also, as well as the yellow wax here?
Well, these are different maturity levels depending on it's the same common source of supply, different maturity levels based on depth and temperature that was applied to the formation.
So it's a depth and temperature
Yes,
thing
sir. Yes, sir.
that you're looking at there. But I see that on your chart, Exhibit N, that you still look at the upper Green River as a potential horizontal target.
The upper Green River? Right now, our current development model is the upper Green River to be a vertical target.
Okay, I just saw that your vertical, pardon me, yes, I misunderstood that. I've
Okay,
got that straight.
no problem.
Okay,
Thank you, sir.
Does the board have any further questions? Okay.
Ms. Tovar, please state your name and business address for the record.
Kayleen Tovar, Uinta Wax, 5128 Apache Plume Road, Fort Worth, Texas, 76109.
What is your current position with Uinta Wax?
I am a senior reservoir engineer, production manager, and ESG advisor.
Okay, I'm going to show you what have been marked as exhibits V1, V2, and W. Do you recognize these documents?
Yes.
Were they prepared by you or Uinta Wax personnel with your supervision and input?
Yes.
Okay, turning your attention to exhibit V1, would you please explain to the board what this shows?
Yes, so this is using a methodology that was outlined by the division. So the Hall and Evers calculations from 1981. This is showing that there's no adverse impact on adjacent lands with reduced setbacks until almost 10 years. And even then it's with a minimal adverse impact.
Okay, and exhibit V2 differs how?
This is just showing the same calculations using the different calculations at the 45-degree in the transition zone, but it is the same result.
And then turning your attention to exhibit W, please explain what this shows. I'd like to point out there's a typo on the slide. It still refers to CH4 Finley, but of course that's now Uinta Wax.
Yeah. So this exhibit just shows that the well economics clearly favor the requested setback reductions. Here you can see how much adding that footage to the wells on a per foot basis adds to additional severance tax and revenue per well.
Bottom line is these wells will be economic.
Yes.
Right. Picking up on what Mr. Doucette asked about on the setback with the existing vertical wells or other vertical or directionally drilled wells.
Mm-hmm.
Do you think, is there any indication that a 330-foot setback would create interference between the wells, or is that adequate to protect the rights of the owners in those vertical wells?
Given the data we have, that should be adequate to protect those vertical wells.
That's been your experience in other areas of the field?
Yes.
Okay. Can you also just briefly address, although I think the board is well aware in the division, the need for these drilling unit boundary wells?
Yes, drilling unit boundary wells helps us prevent waste while still protecting correlative rights to be able to optimize production in the area.
All right. Is it your expert opinion then that the reduction of the setbacks and the drilling of up to 3 drilling unit boundary wells are necessary to recover additional resource that would otherwise be left in the ground?
Yes.
Is it also that the requested spacing in the wells drilled on there will allow recovery of the greatest recovery of natural resources with associated greater economic benefit and without adverse impact on adjacent correlative rights?
Yes.
Madam Chairman, that concludes my examination of Ms. Tovar.
Thank you. Any questions for the witness?
No questions from the division.
Board, do you have questions? No questions.
All right. Thank you, Madam Chairman. At this time, I'd move for admission of exhibits A through N, revised O, and P through W inclusive.
Okay, we have some U1s, U2, V1, V2.
Right. And when I say
Okay.
you, that's what I mean inclusive.
Good, accepted.
Okay, there we go. That one's on the record. Okay. With that, unless the division wants to make a statement, I'll follow up after that.
Yeah, the division would like to make a statement. Division staff has earnestly reviewed petitioner's RAA. Berry Petroleum's response to request for agency action illuminated a potential issue. While Berry has since withdrawn its response, the issue remains. The general well siting rule is only applicable in areas that have not been spaced. If the board issues an order that spaces the subject area only for long lateral horizontal wells, it is the division's opinion that the general well siting rule will no longer apply and could potentially prevent all future vertical development in the subject area. Just for the purposes of administering the resulting order, the division would like if the order could specify or clarify that the areas not currently subject to a spacing order would still have the statewide siting rules apply to them. Or alternatively, if the order were to preclude future vertical directional development, that the order would include such language, just to make it easier for the division to administer the subject area moving forward.
Any further comments from the division? Questions?
No.
Thank you. Board? Okay, we will need to take a few minutes. Oh, I'm sorry, summation.
No, that's fine. We will stipulate to that effect that the intent is not, that the general well siting rule or the existing spacing for vertical wells still apply in the order. We thank the board for your time and attention.
Thank you. We're going to take a few minutes to deliberate, and we will get back with you shortly. We're going off the record now. Record. We have deliberated on this last matter, and I'm looking for a motion.
Okay. I'd like to make a motion that we approve the request for agency action as requested by UNOX with the stipulation that what the division requested on the record be included, and we contain the agreement arrived with Barry as part of the order.
Do I hear a second?
I second.
Any discussion?
None from the division.
Shall we vote?
Yeah.
We're just going to do a voice vote. Aye.
Aye.
It was unanimous. Mr. McDonald, would you please prepare the order with the requested language?
Certainly, Madam Chairman. Thank you.
Thank you. I think that was our last issue of the day. Do I hear a motion to adjourn?
I move we adjourn.
Thank you. We don't need a second on that. Thank you, and we'll see you sometime in the future. Not sure when. Take care.